So, good evening, everyone. I welcome you all to Phantasia, and we are going to start things off with LogoLex, a combined effort of Fullstack Club and CIP to explain why brand guidelines and how to brand guidelines, to be honest. So, what is a brand guideline? I'll just start off with simple things. Uh, does anyone have any idea what a brand guideline is or what a brand kit is? Any bright minds? Anyone? Hmm.
Brand kit is a kit which consists of all the rules and guidelines on how to use the assets of a brand like a logo or a trademark.
Okay, so the dictionary,
Yeah.
the dictionary meaning, right? So how I'd explain it is, it doesn't have to be a big document, right? What is a brand guideline? It is an art. It is a demonstration. It is an explanation, a celebration of your creativity and how you show it to other people, how you identify, right? Now the definition goes, brand guidelines are a set of standards and rules an organization uses to maintain consistent brand messaging, visual identity, and overall brand experiences across all channels and touch points. Where is this needed? Now, say I am a startup, right? I am a startup or I am a successful business. I have multiple social media outlets and I have multiple places where my logo is needed. Why is it necessary to have a brand guideline? It ensures that my logo or my identity, the font I use, the colors I use, the meaning behind them is even through and through all the platforms. This is what a brand guideline means. But best yet, it would be I show you one very popular brand guideline. So Fantasia, we have taken the theme from Netflix. It is only apt that I show you the brand guideline of Netflix itself, right? So here we are. I would like you all to bring your attention to the screen for a second. So everyone is aware what Netflix is, 21st century, right? All of you watch shows, Suits, Breaking Bad. Now, we all are familiar with the N of Netflix, and it is as easily as recognizable. You see it anywhere, and you're like, yeah, that's the Netflix N, right? How have they achieved it? So if you go through their brand guideline, which they have an entire website known as brand.netflix.com, they display what the N symbol is. They display what the word mark for it is, how they would display Netflix, which we have taken inspiration from. They would display the exact color and the hex code that is supposed to be used. They will even mention what is the clear space that is supposed to be used so that there is no clustering in the brand guideline, right? Now, if you go further, they show some prints, so multiple ways the brand guideline has been used. The Netflix logo on multiple backgrounds. The readability, how much readability is allowed, how many shades of black are supposed to be there, special use word marks, co-branding principles, partner logos. They go in depth with this kind of stuff, and it is a good message because all of you understand the Netflix logo as easily. You would see the letter N, you would understand where the Netflix logo is, right? They even mention, they go into detail as to what all to avoid, stretching and altering their logos. So this is a brand guideline. Another example would be one I have made for the recently held Geneva, the Tech Fest of Bennett University, where we made a brand guideline where we discuss what it is, what exactly is to be used, the time group logos, Bennett University logos, how the Zenivia logo is to be used, what can't be done, logo types, alternate logo types, clear usage. We mention everything in depth detail so that when I give my brand guideline to someone, they understand that yes, this brand needs to be represented in this format, right? That maintains consistency. Now there are many other things which are regarding like related to a brand guideline, right? So one of them being the legal aspect of brand guideline. Now I'm gonna move forward with the event now. First of all, it is an absolute honor to welcome a distinguished legal expert to our speaker session today. With nearly 30 years of experience across civil, criminal, corporate, and intellectual property law, he has built a reputation as one of the leading legal minds in the country. As the co-managing partner at Jotwani Associates, a multi-specialist law firm, he has represented Fortune 100 companies, multinational corporations, and individuals, providing strategic counsel on complex legal matters. Beyond his legal practice, he holds 2 US patents in e-discovery processes, has authored a book on competition law and intellectual property rights, and contributes as a faculty member at leading institutions. His passion for the law is unmatched by his commitment to his pro bono work and advocacy for marginalized communities. Please join me in welcoming Mr. Dinesh Jotwani.
Thank you all for having me here. It's my first time at Bennett University, and I was very glad to see the campus. I was telling my colleague that it's a, it's really a pleasure to see these kind of campuses nowadays. So, and I was promised that I'll be given a tour also. So good. I'm glad to see that so many students. I understand it's the weekend evening, but thanks for taking out the time. As I was introduced, my name is Dinesh Dutwani. I'm a lawyer at Supreme Court of India. I practice in all the courts. Now we are practicing. And mainly, I'm an IPR lawyer, intellectual property rights. So let me try to understand the audience. How many of you are engineering students? Almost all of you. Good. And what about law students? Here. So, intellectual property rights is subject which uh, which is the intersection of various subjects. Okay, this is better. So, intellectual property rights, as I was saying, is an intersection of several subjects: engineering, law, business, life sciences. Okay, so and I have been practicing more than 2 decades in IPR zone. We're talking about the brand guidelines. So these are brand guidelines are normally by the organization. But what I'll be talking more about today is protection of intellectual property rights and why they are important and why engineering students should know about it, why law students should know about it, why business students should know about IPRs. Okay. So just let me log into good. We actually I prepared 2 slides, so I was not sure whether I'll have engineering students or law. But then this is basic, which will touch uh, all students of intellectual property rights. Today, I will say I'm also a student of intellectual. With new age coming, artificial intelligence and blockchains, and new technologies coming in, we are learning. The courts are learning about it. The courts not only in India are learning about it, the courts worldwide want are having challenges with new kind of technologies being there. Okay, so we're going to talk about patents, copyrights, geographical indication, the role of industry, which will touch everyone. Uh, to start with, actually, let me reconnect. I had downloaded this. Let me see. Okay, all right. So anything that gets created by way of your mind is intellectual property. Okay, it's the real property everybody knows. Okay, the furniture, the real estate, which you can touch and feel the table. That's the real property. IPRs is what gets created by mind. So we were just discussing Google, fantastic word. Does it have a dictionary meaning? No. Kodak, does it have a dictionary meaning? No. All these are which have become a brand. Microsoft, so maybe a combination of two dictionary words. But all these brands which have become big may not necessarily have dictionaries. They are created. They are created by mind. We have, of course, dictionary meaning. Reliance is a big corporate. Adani is a surname, right? A surname may be common in Gujarat. So there would be exceptions. We'll talk about it. But mostly, I will tell you the marks that are point marks are the best way that you know, are best intellectual property. So let's talk about patents, copyrights, geographical indications. I'm told that there are a lot of computer science. How many of you are computer science students? Oh, all of you. Looks like all of you. All right. So for you guys, both patents are important and copyrights is very important. The source code that you write, and we'll talk about how you protect the source code. Okay, the applications that you can generate. Uh, so this is an agenda that we'll have. We'll talk about all kind of ideas. This is about my firm. As I said, almost 30 years. Uh, and yeah, so currently we are 55 professionals. We're based in Noida only. We have, by the way, we have many engineering students also who work for the law firm. Because as I said, the kind of patents that we protect need engineering mind in that. They should be able to understand the code. They should be able to understand the flow chart. They should be able to understand block diagrams. Maybe a lawyer doesn't, simple lawyer will not be able to understand the BA and LLP. So we need engineers, life sciences, the DNA sequencing part of it. Okay, so all that molecular biology kind of invention. So engineering and patents are intertwined. So we have many engineering. What I wanted to convey was we have in these 55 professionals, we also have engineering uh, associates who would work on several technologies. Okay, these are our partners. Dilkar is here. It's myself. One of the judges is also part of our former judge, of course, is also part of our law firm. All right. So let's start. IPRs. As I said earlier in the introduction, it is creation of mind. Whatever you or whatever you can think of can be protected and can be protected in any form. So it has to be something creation of mind. I used to have a slide, so in different presentation, which talks about big companies like Google, Microsoft, Amazon. If you look at their value of their intellectual property right, okay, it is 90%. If you look at the whole value of the whole company, 90% is intellectual property rights, 10% is their real estate. They have offices, they have staff. Staff is not a property, but yes, any assets that they may have. That's only 10%. 90% is intellectual property. So all the big companies, Fortune 100 companies in the world, their assets, the real assets are becoming less and less, and the IPRs are becoming more. So it becomes more important for them to protect their brand. Okay. Let me ask you, is Phantasia protected? Have you filed for it? It's been 2 years you are running this event. Did anyone file it? No. Okay. So tomorrow, somebody may come and say, I we want to have this event, Phantasia. Who protects it? And you will go to court and then fight, get it registered, right? So the value, again, I say, I mean, there is a value of building land that Bennett has. But why has it acquired? Because of the brand. It's a very old brand. Everybody would know Bennett Wood, which runs. Science of India. So that brand has a value. Why you took admission here is because of the brand. Okay? If, and why it got the land here is because of the brand. Again, I will say. So it is all intertwined. As I said, IPRs are perhaps more important than your real estate. That is, as I said, most of the companies uh, now I'm talking about the Fortune 500 companies. 90% of their assets vest in IPRs. Okay, and IPRs include not only this. This is the list that I was telling you, but it has. Let me just share the next slide. How much time I have for this?
An entire hour.
Oh,
Please
okay.
take your time.
Okay. No, I can speak hours and hours, but so I just want to be mindful. Okay, these are types of IPs. Uh, as I said, it's not limited to patents or brand names, but very powerful kind of intellectual property, trade secrets. So if for example, Coke formula, nobody knows about it. Okay, the recipe of Coke, no one knows it. What would have happened if Coca-Cola around 250 years back would have patented this chemical formula of theirs and not trade secreted? Everybody would be making Coke at home because patent application gets published. I would say the more powerful kind of IPR are trade secrets, even powerful than patents or even powerful because if you can maintain trade secrets like KFC does, KFC or McDonald's does, what they do is how they prepare burger or how they prepare KFC that even children want to have that chicken again and again. What is the formula? What is the recipe? How they prepare it? How they procure the chicken? All that is trade secret. Nobody knows about it. So, what I'm coming to is uh, trade secret is another form of IPRs, which is very, very important, and nowadays even more important. Even more important. How you protect your source code. You may not reveal the whole source code in the copyright, but you may have some trade secret kind of a part. IC layout design, integrated circuit. Any electrical engineering student here? No, nobody. Okay. So they would understand the value of IC layout design, which is a separate act, by the way. Okay. IC design, IC layout design is a separate design, industrial design. So there's a design act. India has a design act, right? So how do you protect the shape? If there is a unique shape, how do you protect it? Suppose it was for the first time, you have a small table along with this table. So this is a new design. Maybe it was protected. First time when this kind of a design came, they would protect it so that nobody else is able to copy it. So especially for uh, mechanical engineering student, anyone from mechanical engineering here?
Mostly
No one.
CS.
Anyone use AutoCAD? You use AutoCAD. Okay. So you understand the importance of designing. Okay. Sorry? Basic, yeah. So what did you design in AutoCAD? Sorry? Okay. You can actually design everything. You can design as an interior decorator, you can design a building. So all that can get protected under industrial design. Traditional knowledge is one way to protect. So I'll not get into that controversy of it. Because it's a very like Haldi is an example where there's a lot of dispute going on. Geographical indication. So Kashmiri Pashmina shawls, Kolhapuri chappal, their Rasgulla coming from Bengal. That is a geographical indication. Okay, so we have this alcohol from Switzerland. Agra Petha. Agra Petha. So if somebody has a shop called Agra Petha, but he is not procuring it from Agra, he is actually violating it. Okay. So The wines of Switzerland. What's the name? Ankit, you would know that. Okay, the single malt that comes from Switzerland. It should come from Switzerland. You can't copy it here. Okay, the Napa Valley grapes, the Napa Valley vines that are there. No, I can't make a Napa Valley here in India because these are geographical indications. Okay, so very important. Kolhapuri chappal. Can I start making the Kolhapuri chappal in Delhi? We can't because it's protected. It is only the artisan of Kolhapur only can make it. All right. So again, different copyright. We'll talk about it later on in detail because all of you are computer science students. Very important for you to understand copyright law. Okay, because what you are doing day to day coding is nothing but it gets protected under the Copyright Act. All right. So these patents, of course, we'll be talking about patents in detail because it touches every engineer. Every engineer it touches. We'll talk about patents also. And of course, law students are there. Important for them to know the process of registration. Maybe the invention is done by engineers, but and got code is written by engineers. But as a lawyer, what do you do? How do you protect it? How do you go to court and protect in IPR cases? We'll talk about that. Okay. All right. Role of IPR in industry. Of course, this is very important for you to understand whichever company you join, whichever industry you join. What it does is it encourages innovation and creativity. Creativity, very important for you to think of new ideas on how you can be efficient. DeepSeek, small company now shaking the Wall Street completely. It's nothing but an innovation and creativity. And why they were able to do it is because of patents. Okay. Uh, we'll talk about that also. Promoting industrial growth and competitiveness, very important when there is a competition in the market, especially two brands are competing among themselves. So how do you protect and promote your brand is very important where the branding guidelines come. Ensure consumer protection and quality assurance. So if I know that this product is coming from some FMCG company, I would say, okay, I know that this is it's a such product. It's a Hindustan Unilever product. I will come to know. So they have protected that as a brand. I know it is a Lenovo, it is an Apple. So it's kind of a consumer protection that you get. I will buy a Apple product blindly. I know its quality. I will buy a Samsung phone. Perhaps. I know its quality. Strengthening the creativity and cultural industry, entertainment industry, the movies that you see. We're talking about Netflix. Uh, Very important for IPR industry. In fact, a lot of disputes are happening in the film industry and the music industry, the creativity part of it. So again, uh, that's where it strengthened the cultural part of it. Economic benefits and job creation, of course, that's very ultimately what is happening is it improves the revenue of the government and it gives an employment opportunities. So you can see my firm, lot of 85% work is IPR. Why is employment generation? Because we do all kind of protection. Every industry needs it. We talk about it. Every industry needs protection of IPR, one or the other. Branding is, of course, that every industry needs. From automobile industry to FMCG to pharmaceutical industry. Everyone would need protection. That is through intellectual property. All right. Uh, of course, it attracts FDI. There are a lot of startups that can get that are available for sale if they have a good idea. And I'll give you an example. This is like 15 years back. I used to live in Pune, and I suddenly realized that a company, very small company, with 30 employees, and being being bought for $10 million. I said, why $10 million? Not even 30. $10 million that time was less, but even that was good amount for them. It's just because they had one patent in there. Okay, and that patent actually was an eyesore of a big company. So they paid promoter $10 million to buy that company. And of course, when they bought the company, the patent became theirs. So and all the investment came from outside India. So FDI, from FDI perspective, very important that you protect. Okay, so patents features I have talked about it. It's a territorial right. You can protect the patents actually are live for 20 years. All right, and it gives you a monopoly. What are the three things? What are the how what are the criteria for patent? It should be novel. Novel means new. Okay, it should be a new idea. Then only you can patent. If there is something you already done anywhere in the world, maybe it's done before in USA. That's why we are able to oppose so many patents in US. It has to be an inventive step, means something very concrete. And third is industrial application. We should be able to use that. All right. So if you have these three criteria, if in your mind that it is new, it can be applied to an industry, and it is a little incremental thing that you have invented, whether in a mechanical shape, new shape, maybe you have given it a little bit of hinge, whether it's a new feature that combines a algorithm somewhere, go ahead and protect it. Especially, don't undermine your idea as an engineer. I would say I would used to do brainstorming. Say, tell them, okay, go ahead, protect this. Don't undermine your idea. Of course, you can do a search for novelty. You'll have to do a search. Do a simple Google search. Of course, there are once you approach a lawyer, they will like us. We have tools, databases that we will do a proprietary search for you. But then that may be paid. But you should before if you think you have an idea, just do a Google search to see if it is new or not. Okay. All right. So this is role of patents in all kind of industry. We talked about pharmaceutical and biotechnology. Pfizer COVID-19 vaccine patent has ensured exclusive production rights. In India, of course, government had taken it over all the rights, so that available. But yes, Pfizer was able to patent that very quickly. All kind of medicine get first of all it gets protected. Any chemical engineering? No, okay. Mostly that means computer science, information technology, and artificial intelligence. A Google PageRank algorithm is patented to protect its search engine technology. When you search for something, some pages come. How does Google decide that which page to show you? Okay, all that algorithm is patented. That's why Google is able to lead the market. Of course, a lot of that is trade secret also. We'll come to know about it. But Google's algorithm, part of it is patented and part of it is trade secret. How do I am able when I search for something, I find relevant searches in Google, and why not in Bing or Yahoo? Is because of their searching. All right. So automotive engineering, of course, there are in automotive engineering, and I was taking this session only 1 week back with a lot of MSME industry, which were from the automobile industry. Okay, so there the design helps, how the mirror, how the bonnet looks, how the steering wheel, dashboard. Every car has a different shape. So, and I gave an example that Mercedes had 350 designs registration. Okay, one car has 350 design registration, and then they have to register in each country also. All right. Some challenges when you patent, of course, it's a complex war. It is high cost. There are some ethical concerns also. Today only I was reading in the Economic Times about a lot of these proprietary databases when the artificial intelligence uses that data without giving them a credit. For example, Times of India, Economic Times. So AI engine would use that information to deliver you the quick results, right? Now, Times of India and Hindustan Times and all these are copyrighted matter. Can they use this copyrighted matter and give you the results? That is a challenge in AI. These companies say you are using my database. Times of India is since more than 100 years. We have this database. If you use my database and AI uses it, what? And it is my copyright. You should pay me some royalty, right? So they are right, absolutely. And this kind of litigation is going on in US also. So there are answers still to come. But the fact is that right now AI is being used with whatever database there is in the servers. Servers may include newspaper, books, archival data, day-to-day data. So all that, a lot of IPR issues will come. Okay, copyrights. Again, it's a protection of software we talked about, literary, dramatic, musical, artistic work, your music, your movies, software code that you do, an app. Anybody preparing an app? Yeah. Okay, you are preparing. Anyone else? No. You are writing the code. Okay. So once the app is ready, how do you protect it? So that's our okay. So again, copyright your code so that tomorrow none of your colleague or your employee takes that code away. What right will you have? If you're right now you just protect it, you put it in a server. Which server you use for? Which one? Next.js. Okay. Maybe AWS. I don't know. I'm just aware of those. Wherever that code is. So how do you once it is ready, your app is ready and it is in the market, it can be stolen pretty easily. One of your employees can do it, one of your colleague can take the source code away and start his own company. So very important that whatever software you are developing, it should be copyrighted. Otherwise, including some of the good screenshots that you get. So protect that as a copyright. The term of a like patent was 20 years, right? From the moment you file that. Now, copyrights are 60 years from the date of the death of the author. So if you are writing a book, if I'm writing a book after my death, 60 years is the copyright that my children, my legacy would be able to get the royalty. And if it is a computer code, it is 120 years from the date it is there. So copyright has a very long duration of protection because you have produced it, you have worked hard on it. Again, a challenge in copyright is coming from artificial intelligence. It's because I believe the AI can even write codes. If you want to tell the AI to write a code, it will write a code for you. Who owns that code? The AI owns it, or you own it because you gave the prompt of it, or so we don't know who owns that code. Who will have that? I can write a book. By the way, I can tell AI to write an article for you. Write an article, 500-word article on Bennett, Coleman. Then what happens? Write a 500. So who owns it? I don't own it. I didn't do any work on it. AI engine is not a human being or a company that did it. So all these challenges are still going on. So I may not be able to answer actually some of these questions because of the developing technology. Okay. So, but as of now, whatever you have developing as an app, as a website, as any engine, any platform, you should go ahead and protect it because otherwise, if it gets copied, you have no right. Okay. Of course, all the movies that you see on Netflix, they go through a censorship board, so they have to mandatorily copyright a movie or a song, which we see on platform. Yeah. Good. Very good question. Very good question. So, any new business idea that you have, can it be protected? Right? Okay, good. I'm loud enough. So, good question. Can a business idea be protected? Not in India. Our Patent Act specifically says you cannot protect a business idea. But there are ways to do that. Get hold of good, clever patent agent, will protect. And they will do it for you. Take it offline and we in India, the Patent Act specifically prohibits. But there are ways you can claim a system or a device, convert that business idea as if some device is used. Okay. So you have indirect way of protecting. But in US, you can have direct protection of okay. Even in EPO, yeah.
Only
Hello. Is it better?
yes, sir.
All right. So outside India, business method, these are called business method patents. They can be protected. So you can go and file outside. But in India, there are different ways you have to take it as a device claim or a system claim, looking at what your idea is. If it is a new business idea, if you're if you're having a new business idea whereby you can deliver in 10 minutes pizza to anyone in a city, you have a new way to do it. You can you can still do that. Okay. All right. So copyrights. Back to copyrights. As I said, most this is very important for computer science students that they protect their new ideas and not only the code. If you have a new feature in your app, I mean there is a way how Uber works. Uber connects the drivers to the passenger. It's a very simple way, right? Tomorrow they come out with some new feature uh, whereby you can know, suppose you have a rating, but you can know actually if there are any accidents done by this drive, new feature, which has not been done by any app before. So you can protect that feature. All right. So maybe there is an existing app going on, but you think of a new feature. New feature means new feature that has not been done anywhere in the world globally. So if your app has a new feature, go ahead and protect that as a patent. Then Uber itself will not be able to. Okay. Because now that you have got a patent, and then it becomes more valuable your or your startup. All right, let's move on. Role of copyright. This is we talked about entertainment and media, software and IT, and publishing and journalism. All that needs IPR protection, and with the advent of artificial intelligence, advent of blockchain, uh, all this is becoming difficult to protect. Okay. Okay, challenges I've already discussed. By the way, so copyright protection. So in my firm, told you we have around 55 people. Out of that, 35 are devoted to something called licensing. Is nothing but copyright protection. If you have a software, we work for this. I was giving an example. If you are working on a software like any 3D or any designing software that you're working on, and if you use pirated software, so copyright violation is also called piracy. So we go ahead and give legal notices. So there's a lot of infringement that is happening, especially coming out from computer science students. So we get these pings information that this, we can even get the device identification that this is coming from Bennett Coleman University and it is coming from this device and this is a user who is using our pirated software. So all that comes to our client and they give us the information and we have to give legal notice and sometimes take them to the court. So that's what copyright violation most of our law firm does. All right. We talked about it, future of copyright in digital age, specifically when use of AI on copyrighted data, because what the AI engine does, it gives you a result based on some data, and that data itself is a copyright. In fact, there's a big litigation going on in US on this subject and in India too. Okay, so briefly we talked about geographical indication, which is it identifies a product as origination from a specific geographical area. Okay? And it tells you Gulapuri Chappal, Agra ka Petha, example would be there. So these are some examples uh, that we have from Rajasthan, Kathputli from Rajasthan, Basmati rice from Haryana and Delhi and Punjab. So all that is, if you get a product registered as a geographical indication, no one else can produce it in the whole world. Okay, so if we have a Rasagolla from West Bengal, I cannot make it there. Only if the ingredients are from West Bengal, then I can perhaps. But it's not registered as a GI as of now. But yes, it can be. Nagpur oranges, very famous. You can sell it, but we can't have plantation here with oranges and I just start pulsing now Nagpur oranges. That will be difficult. In fact, most of these they have an association that can file a case. If you start using a product which is not from the particular geography to be claiming, they can file a case. One of the things that is necessary for a geographical indication mark to be registered is that you should have an association. They will have an association who will act. Kolhapur will have a Kolhapuri Chappal, they have made association. And they can file a case and stop you from making chappals that are called Kolhapuri. Okay, very, very important geographical indication. In fact, the government of India has given huge hundreds of crores of rupees grant for people to actually come out because India is rich in culture, it is rich in food, and we should protect it. Once we have a geographical indication of a food item in India, no one can sell it in New York. It has to be imported from that particular place. Okay, all right, let's move on. These are some examples. Swiss watches. Can we make Swiss watch here? Can Tata make a Swiss watch here? Uh, Basmati rice. Darjeeling tea is again a good example of GI. You can't have a Darjeeling tea coming from anywhere else. Champagne. Yeah, this is what I was forgetting. Champagne would come from France. I mean, I can't make a champagne in India. It has to be. Champagne is a place in France from where the champagne comes and you can actually sell it in. So if I start making champagne in India, I'll be infringing their geographical indication. All right, I'll move on to. So I think cost is all in all the IPRs that I mentioned. Cost is a problem because not only there is a government fees, there is a lawyer's fees also. Okay, so you have to pay both. And then another challenge comes in protection is everyone except copyright, which you can protect. If it is protected in one country, it will get protected in 150 countries automatically. But it's not the case with patents. It's not the case with designs. So that means you have to go to each country to protect your invention or your mark, trademark. Okay. Some examples where industry would need all kind of IPs. Okay. Uh, so creative industry, they will need patents, food and beverage industry. In fact, I would say all kind of industry would need all kind of IPRs, all different. They need a trade secret also. They need patent. Automobile industry needs everything, patent and of course trademark. Trademark every industry would need a trademark. Every organization, every company would need a trademark. Okay. Every event you should get this trademark. Okay. So every new name will be the trademark. All right. So this was my brief presentation. If there are any questions on IPRs, patents, trademarks, of course, I'm not going into how you protect patents. Whole lot of way to protect patents. Yes, go ahead. So can you tell something about trademark and how to protect your trademark or a logo? Okay. Uh, so trademark. I don't know why we did. I have a different slice for that trademark protection. But we can just talk about it quickly. So when you once you think of a name, say Phantasia or anything that's so unique, you file for a trademark. Of course, you go online on a trademark office website. You first check whether that exists or not. Okay, maybe this exists for Phantasia. Maybe it looks like a like liquor Phantasia. If it is a separate class, then suppose there is a Phantasia liquor, then it is. But you can still go ahead and protect it because yours is an event. There are 45 classes under trademark. You have to see that there is a Maruti car and there is a Maruti cooking. They exist side by side, isn't it? So Phantasia liquor or Phantasia event are absolutely different things. You may still go ahead and fight it. But if they are in the same class, then you cannot be able to. If some other event is by this name, then you will not be able to protect. Then you file it, there is an examination, there is an objection. If the objection is not removed in writing, there is a hearing that the patent examiner will ask for. So there's a whole flow chart of process that will happen. It's a 1 year process. So, but your protection starts from the date you file. In fact, your protection starts from the date you start using. You can say I was using Phantasia from last 2 years. So please predate this as a usage from last 2 years. So if in between somebody is using it, you can sense of that person based on your usage of it. So when you file for a trademark, they will ask you, since when have you been using this mark? You will say 2 years back. So they will say that your usage date is from that particular date. And if in between somebody started misusing your mark, you can stop that. That's called an infringement case or passing off or infringement case that you can file against. So very important for startups. We think they devote so much time on thinking about a name and then you get approval from your company name approval. You also should have a trademark. And then if you think your startup is going to sell products outside India, say to Japan or to Europe, then you have to go and file there also. That's why sometimes these things become very expensive. Okay? Because you're going outside India. Your product is your app is being used outside India. So you should protect in that country. That's why we in India have almost every company uh, wants to protect trademarking. And same with like the name, you have a logo. There's a logo, you can protect the logo also. Nobody will be able to use a logo. It could be a word mark, why it could be combination of word mark. Yeah. So logo is an AI. Don't ask me that. I said I know. Okay, it's not a completely AI, but someone edited it. Is it currently used for like if there are two logos? Theoretically, I don't think so because AI did 90% of the work, you did 10% of the work. You just gave a prompt to it. I want a logo that should be busty and it should have the four flag or the color should be red, blue, and green. You give this command to AI engine, it will give you a different designs with these colors, and you will have a logo in front. Okay, so and I'll just complete. So yeah, so there is a lot of dispute on it. Okay, that's why I say the AI related questions I may not be able to answer because they're still developing. Okay, these driverless cars that are there, if they go ahead and do an accident, who is this, and somebody gets killed, who is responsible? They will say, you sue Tesla. Okay, the person who owns it will say, I don't sue Tesla. The driver will say, I was not driving, I was just sitting, and I was just hit a person. So all that is evolving. Who is responsible for a driverless car doing an accident? All right, you had some question.
So you said that they get very expensive. So is there uh is there an initial cost of these, or it's like every year you have to pay a certain amount to get it um redone and you know take it?
Yeah. So very good question. Why do patents become expensive? Is it like one time you give a lawyer and you are done with? Unfortunately, no. The system that we have, each there's something called annuities. If you have to maintain your patent, each year you have to pay annuity fees. And suppose that annuity fees, and that's increasing. I don't know why, but the government of India has increased the annuity like anything, and it's a business for us as lawyers. We have no problem. Not only that, but when you go out, suppose you have your patent is valid in 5 other countries, you pay five annuities. You can imagine a company like Microsoft, which has 1 lakh patents a year, which they file all across the globe, and they have to pay annuities for lakhs of patents. So you can imagine the kind of budget that, or just for patents itself. So it's an expensive proposition. Again, yeah, you have some. Anyone else has? Most of us are students. And since students were generally we have some startup, we have some things that we do for my parents. So how would you suggest for a startup like if you are register this for a copyright and trademark? We don't know any lawyers, we don't know how the government functions. But if we know that there is a government portal, we can go on, we can log in and we can this you suggest some ways that how we can keeping the cost now easily we can do. So very good question. So once you are start out, you register yourself as a startup at the Government of India portal, and you register under MSME. So there are in MSME there are programs. So I am on panel of the Government of India, MSME and startup. So if anybody wants to file a free patent, they should be registered under the portal, and government will give you. And the scheme is not only in India, so they give you 1 lakh rupees. They're going outside India. Same for the trademark. So please register yourself under MSME program. They have a robust IPR program, and you will get a grant. Of course, you will have to contact an attorney like us who are registered with MSME. You have to be registered with MSME. So once we get empaneled there, we can file patent trademarks, copyrights for you, and for you it's free of cost because of the government of India grants that. And by the way, it's very efficient. I heard that they give very promptly within 2 3 months they give full cost. So initial cost you may not have, your accounting will clear, but I will get the fees from the government and they will reimburse me next year. This is okay. This is okay. Okay. Yes, ma'am. So I get the patent. Yeah, it is for 20 years. Annuity will be each year you have to pay. Can I?
Can annuity breach that time period?
Annuity breach the time period. How, what does that mean? So why don't you come and tell me? And little each year you have to pay. Yeah. No, 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 you can't do it. Money can't buy everything. Okay. So that will be called evergreening of patent. Good question. So these terms are called evergreening. If I pay annuity for 100 years, no, your patent gets expired in 20 years.
After
And
that,
what again I suggest is have a clever lawyer, patent attorney, who will little bit modify your, especially this happens in pharmaceutical industry. Your patent your medicine starts earning after 15 years. And there's only 5 years of commercialization. They say, oh, we want to earn more. So what they do is they file a little different molecule as a patent. Okay. And efficacy is same and the name is same and it continues. Your patent gets renewed for another 20 years. So you need to be, I will say, a little clever in that respect to evergreen your patent. Not by annuity. That initial patent will expire, but you can evergreen your patent by tweaking it a little bit so that, for example, Amazon one click patent, which is for 20 years. 20 years haven't finished, but they are thinking of making it instead of click the touch part of it. It's a little tweaking, and it will again extend for 20 years.
sir, but the previous patent has been now made public, so anyone can access. So for example, a
Yeah,
pharmaceutical company.
Yeah, they can, but my new patent
Yeah.
will be able to block any new infringements because it's a very minor tweak that they have done. Okay, it's a good point because earlier patent expired. Now anybody can make that medicine. You're right. But my new molecule will be such that it covers the previous one in a little different way.
Hmm.
So still people will not be able to produce that molecule. Okay. So especially this happens in pharmaceutical industry. Doesn't happen. Computer science is very fast. Technology gets outdated in 5 years, 7 years, something else. But with pharmaceutical medicines, they want their medicines to last 100 years. Okay. Yeah, you have a question.
Jotted down full-fledged business strategy and that business plan be copyright.
Business?
Business plan. Oh, which business strategy and that be
Business
copyright.
plan. Well, there are, again, I say there are smart ways to protect it. Business plan. Okay. So if there is a new feature in your business plan, you can protect it. In India, you cannot protect it. Their business method patents very specifically written in Patent Act will not be protected. Yeah. But perhaps what you can do is protect that as a system, as a software. To protect that as a device, protect that as software. Even software, pure software are not cannot be done in India because we have a very old system of protection of IPRs. Whereas all worldwide you can protect software. Microsoft itself is a software company. It also gets a lot of patents in India. Is why? Because of the different way you can put a device restriction, put a server restriction. So that way you can protect it. There was one more. Okay, so we'll take two more questions. Anyone? Yeah, two have. No, no, not mandatory. No, you register your trademark in your personal name because company is not yet. Lot of right now we are handling one case where this lady is in Singapore. She wants to protect a trademark and form a company. Now, company formation for a Singaporean citizen, they need 2 months, 3 months because of ease of doing business in India. Trademark can be filed easily, right? So, what she has done is she has filed the trademark in her own name. When the company gets formed, she will do an assignment of that to the company, to the startup. You got it? So what if someone registered a trademark in China, but goes on with the process of it's a risk. It's a risk. As I said, Phantasia is a mark that is being used, and you haven't got it filed for a trademark. Someone else starts using it. Now you don't have a registration. You will file a case as you using it from last 2 years. What is the proof? You will bring Mr. Dinesh or Vani as a witness. You will show the YouTube clippings that I've been using it from last 2 years. But it becomes a very difficult process. The other person will contest it. If it is registered, so all these registrations make your life easy, take you away from the court cases. And many times happen if your mark, if your event becomes very famous, then uh, then there will be a lot of copying. The moment it becomes your product becomes famous, people will start copying. So it's not necessary, but it is 100% advisable to protect your trademark because you don't want to get into this. Same logic goes with copyright. I can prove my copyright. I wrote the book. What is the proof? Right? I have a copyright. So we can take last question if there is. All right.
Sir, I'm a designer. I design logos. Let's say if I search AI for some logo. Now I want to make that logo, but not exactly that. I do some changes into it. I just took the inspiration from it and I made that logo. Is that correct usage of IP laws later on for that logo?
Good question. Very good question. So Devdas movie has been made thrice. One with Dilip Kumar, other actors came. Shah Rukh Khan. Shah Rukh Khan was also in Devdas. This movie has been made 3 times. So if there is something that is there, you worked on it, then that is your copy. That's what I want to say. So if you developed a logo and no, so AI developed a logo and you worked on it. Depends. If you just work some like 5% changes or 10% changes, then the AI won't do. Not all. But if you really work, so the storyline Devdas was written way back in a novel, but that was copied again and again. So there is no copyright in a story or an idea. Copyright is expression of your idea. Okay, so you express. So Devdas movie was in the expression of idea was done 3 times. So similarly with your logo, you got an idea from AI, but you worked hard on it. Okay, you put in a labor there and made your own. Then that is your own copyright. That logo will be your own copyright or trademark, whatever way you want to put it. Okay, very good conversation and questions with all of you. I enjoyed this session myself. Okay.
If anyone has any questions,
Okay, we can wait for 5 more minutes. Anything on IPRs, patent, trademark, copyright, we can talk about it.
any advice in general?
All right, good. So everybody understood that. Okay, yeah.
So can you differentiate between these three: copyright, patent, trademark?
Also, rest.
Exact difference.
The exact differences.
These are all three different kinds of creation of mind. Patent is your inventions.
Or invention.
Yeah, आविष्कार जिसे कहते हैं. आप laboratory में invent a molecule, or you give a new design, or you have a new feature in your app. that have not been. I was giving example of Uber, which can predict how many times the driver has been convicted. Maybe it's a new idea. Okay. So any new invention is patent. Any new expression of an idea is a copyright. So how you express this. I was giving example of Devdas. Devdas had it been a patent, perhaps only 120 years. But copyright is something you really worked on. That's an expression of an idea, like a book or like a software. The code you write. The code you write is actually like a book, right? Okay. I've done coding myself, so I understand how coding is done. So it's like writing a book, like writing a logic, a flow chart, a decision box. All that is copyright. And trademark, of course, is something visual. Logo. Okay. The way you can see it, the color combination that is. Of course, there are three different ways how you protect it in the patent and trademark office. That requires a lot of going into deep, the forms that are required, the declarations that are required. That's a process that lawyers will do it. But from your perspective, as I said, anything that is created by way of mind can be protected. Trade secret, again, we talk about trade secret, right? That's also a very powerful kind of intelligence. Because I am not telling anyone. If I know a way to take way from going to Greater Noida, my office in Noida, and nobody knows about it, I will not share it. It's my trade secret because I reach early, because I start telling everyone, then everyone will use that way. So trade secret can be anything that helps you.
So
Okay.
if you get that trade secret registered, तो क्या वो root को use नहीं
ट्रेड
कर
सीक्रेट
सकता?
रजिस्टर होती है पहले बताओ.
मतलब as in you get that as a trade secret, तो फिर in that case क्या वो root को use नहीं कर सकता?
नहीं नहीं, I can't exclude others. That's a problem ना. If Coke trade secret comes out in the market, it cannot stop anything. Then it is no longer, by definition, it is no longer a trade secret. But the way they protect their trade secret is just amazing. The way McDonald's does it, the way KFC protects its trade secret, they have different rules. You know, the one book doesn't has never met the other book. The one who bakes will not be garnished. So the way they do it is their trade secret, and the moment it comes out in the market, it's no longer called a trade secret. And there is in India you cannot protect it, you cannot register a trade secret, whereas in other countries you can. There is no way you register.
I have a question, sir, regarding this. So we all know that Coke's secret for making the drink, right? No one knows about it. But then we've also heard of cases where people get penalized or they face some charges on them for trying to sell it to other people. Now, if it's not a trade secret and nobody knows about it, how do they get penalized for something they aren't even sure?
Very good question. In fact, I was coming to that part. Is suppose you unethically got from Coke only, you signed a contract with me that you are my employee, and you of course I will have to tell my employee about my trade secret. And then you went and told that to someone else. So then I will sue you. That is a penalization because you leaked. If you independently found out the Coke recipe, you're not connected with Coke, but you were my employee and I gave you that information, and you gave it to third person. So I will file a case against you and that person because you breached the contract of confidence. And that's why all your employment letters, first thing that will be done is IPR assignment and confidential.
Sometimes it's
NDA is non-disclosure. So all these are extremely important for a technology company. You are making an app and your colleague takes all the code from you, or your employee takes it. Of course, you have to give them access. That doesn't how they access it, right? So once they access it and your employee gives the code to someone else, then I can penalize. Okay, all right, good. Anything else? Thank you so much. Both will time to the are practically doing. I think that's great. Any painting that you can make, anything that you can make also, any new cooking dish that you can have, you can check that. Okay, all right, great.
Thanks. First of all, thank you so much, sir, for such an invaluable session over patents. I believe everyone over here has learned something about patents today, has understood, and has taken the first step into the world of law. For the students of law, I think you've already taken your first step. But for the students of CSE, right, we usually are into more of the business of creation, where we try to ponder into what we can do next. What is the next big thing? शायद से अब AI आ गया, अब AI के regarding में क्या कर सकता हूँ? My next big project, what can it be? We never deep dive into the has anyone already done it? Has anyone made a patent about it? Was there a patent made about this 15 years ago? I believe everybody has learned a valuable lesson today, and a huge amount of applause to sir. Thank you so much, sir, for sharing your invaluable insights with us today. Your deep expertise in litigation, corporate law, intellectual property, and cybersecurity has truly enriched our understanding of legal landscape. We appreciate the time and effort you've taken to be here with us, and your perspectives on patent laws were incredibly enlightening. Your dedication to the legal profession, as well as your contribution to education, are truly inspiring. As a token of appreciation, I would now like to invite Sir and Mr. Vital onto the stage. We would impart a token of appreciation. Token of appreciation.
Great to see so many people Friday evening, young people. Aman,
Everyone for one group.
yes, yes, absolutely. We do that. Okay. Yeah.
I request everyone to come.
Lunch.